All right, good morning. Welcome to Inside Pages on a Metro Television. My name is Aldo Moro. It's a pleasure coming your way. It's a beautiful Saturday morning. Here on Inside Pages, what we do is that we look into the pages and come up with the topical issues for the week. And then we invite the right guests and then ask them the relevant questions on your behalf. And that's what happens here on Inside Pages. Now, this morning is about Aisha Huang. Aisha Huang, Aisha Huang. I mentioned her name 3 times. Very powerful Chinese woman who's been involved in illegal mining in this country for so many years. Finally, she has been jailed. A high court has sentenced this Galamsey kingpin. I don't know if we can describe her as a kingpin because she's been a woman, but she's been sentenced to 4.5 years in jail and on 4 charges, and I'll be reading the 4 charges to you. But it's not just about the fact that she's been jailed finally, but it's about whether or not we're putting our best as a state, whether the right charges were preferred against her. Were we lenient, for instance, with this Aisha Huang case or not? It's a big debate that's actually out there. And then for us, the most important question would be, what does this mean for our fight against illegal mining? So today, if I'm in illegal mining and I heard about Aisha Huang being jailed for 4.5 years, is that enough to deter me? Is that enough deterrent for persons who are involved in illegal mining? What has also happened to the others who are supposed to have been prosecuted by the state? We know about Akunta mining. All of these issues are coming up. So we'll delve into that shortly when we come back. My name once again is Aldo Moro. This is Inside Pages. Inside Pages returns shortly, and I'll be introducing my resource persons, both here and those who are joining us digitally.
Before judgment today, Aisha Huang pleaded guilty to the last count, which is unlawful entry into the country, and was convicted on her own plea. Justice Lydia Sema-for, while passing the judgment, indicated she had considered the plea of mitigation by the defense lawyers and the submission of prosecution. She said the prosecution provided reasonable evidence to provide their case. She also added that the fight against the menace must be a collective one. Aisha Huang's lawyer Miracle Atache prayed the court for a fine and deportation instead of a custodial sentence. He also prayed the court to consider the financial burden on the country should she, Aisha Huang, be imprisoned. His prayer was, however, opposed by the Director of Prosecution, Yvonne Atakra Ubu-Obisa, who prayed that the court imposes a custodian sentence, a fine as well, and also deports the convict after serving her jail term. She prayed the court to consider the level of devastation occasioned by the activities of the convict. Justice Lydia Osema-for, after listening to both parties, jailed Aisha Huang for 4.5 years with a fine of 48,000 Ghana cedis. The Deputy Attorney General, Alfred Tuayeboa, after the court ruling, told journalists that Aisha Huang's fate should serve as a deterrent to other persons engaged in illegal mining.
Aisha Huang, as we all know, she's someone that has gotten her name in the media a lot. Today, she's come to the end of the road. We're able to successfully prosecute her. She's going to spend 4 years, 6 months in custody. It should be a lesson to the others that you may be engaging in illegal mining, but when your time comes, the law will deal with you in accordance with what we have had. So it's a fight that we have not won. It's a fight that is a continuous one. As I just said, we all need to take part in the fight.
Aisha Huang was arrested for her involvement in illegal mining activities and later repatriated, but unlawfully returned to the country in September 2022. The Attorney General Godfred Yaboah-Dame seems not to be pleased with the court's judgment as delivered by Justice Lydia Osema-for in the matter of the state versus Aisha Huang, who was convicted on December 4, 2023. In the latest development, the Attorney General, though appreciative of the swiftness and efficiency in which justice has been dispensed, says he will test the soundness of the decision at the Court of Appeal to ensure a new sentencing regime is effected and applied to the accused person. The stance is firm by the fact that the Minerals and Mining Amendment Act 2019, Act 995, imposes a minimum of 20 years in prison for a non-Ghanaian, together with a fine between 100,000 penalty units and 350,000 penalty units. Now, Aisha Huang was convicted on 4 counts after she was found guilty of her involvement in illegal mining activities. Her case between the state saw the prosecution call 11 witnesses giving varied reasons for which the Galamsey kingpin should be convicted. Elvisando, Metro News, Accra.
All right, that's just to give you a sense of what happened in court at the Accra High Court Criminal Division. It's about the Chinese national. She's called N. Huang, but we popularly call her Aisha Huang. She's been sentenced to 4.5 years in prison for engaging in illegal mining in Ghana. She's also been slapped with 48,000 Ghana cedis fine, which is also to be deported after she served her jail term. This was after the criminal division of the Accra High Court, presided over by Justice Lydia Osei Mafu, found her guilty on the charge of undertaking a mining operation without a license. She's engaged in mining without a license, facilitating the participation of persons engaged in mining operation, and also the illegal employment of foreigners. Now, she was also convicted on her own plea in the charge of entering Ghana while prohibited from re-entry. The case was on. The case was, the Attorney General filed a nolle prosequi and asked her she be repatriated. And then somehow she found her way back into the country, but this time with a different forged personality. And that's what she has actually accepted. And she's been actually convicted based on her own, her own plea. Now, it was the court's opinion that the state, led by Director of Public Prosecutions, Yvonne Atakra Obobisa, has proven beyond reasonable doubt that Aisha Huang committed the crime. Of course, when she was facing the judge in her usual nose mask and, a white scarf, Aisha Huang was calmly seated in the dock 1 hour into the reading of the judgment. While Aisha Huang had denied all the charges, it was the court's view that she contradicted herself in her defense statements in the trial, which lasted for 1 year, 2 months. Miracle Atachi, was the counsel for Aisha Huang, in his plea of mitigation, said his client had been in custody since October 2022. He is therefore praying the court to impose a fine and deport his client instead of custodial sentence. And I'm going to quote him. It is our humble prayer that a custodial sentence to the accused would exert another financial burden on the state, particularly the prison service. So she has made the work of the prosecution and court more expeditiously, to move expeditiously regarding a re-entry charge. But of course, in a sharp response, the Director of Public Prosecution said, taking into consideration the impact of Aisha Huang's action on the families and the witnesses who testified before the court, it was imperative for the court to impose a maximum custodial sentence and a deportation order. In conclusion, it says, we wish to state that because of the indignity with which the accused person operated, the sentence should reflect the impact of her actions on the people of Ghana, the communities that she had permanently impaired, and the livelihoods that she took away. Just a bit of a background, just briefly, for those of you who may not have been particularly following this particular case. Now, N. Huang, as she's officially known, of course known as Aisha Huang popularly, she was accused of being in the thick of affairs of illegal mining, Galamsey, especially in the Ashanti region. She was deported from Ghana in 2018 after the Attorney General decided to discontinue her trial, in which she was accused of engaging in small-scale mining without license. However, she was said to have sneaked back into Ghana to allegedly engage in the same activities for which she was deported. And then in October 2022, the Attorney General then decided to prosecute her for the alleged crimes before her deportation and new ones committed since her re-entry into Ghana. It was the case of the prosecution of that Aisha had she had a legal mining concession at Bipo Tinting in the Amansi West District in the Ashanti region, and also operated a mining support services Company. She had pleaded not guilty to undertaking a mining operation without a license, facilitating the participation of persons engaging in mining operation, the legal employment of foreigners, and entering Ghana while prohibited from re-entry. But on May 3, 2023, Aisha pleaded guilty to entering Ghana while prohibited from re-entry, contrary to Section 24 of the Immigration Act 2000, Act 573. That was after she had entered into a plea bargaining agreement with the State Office of the Attorney General. So that's it. There's a legal, angle to this conversation, which is the old law versus the new law. She was prosecuted based on the old law, because remember that her case actually was running from 2015 to 2017, right? And the old law was actually, the new law was promulgated in 2019. So there's a big debate as to whether she could have been charged based on the new law. Okay, and now that there's a new law, can we go back to court with a new law and sort of re-prosecute her, so to speak? I'm not a lawyer, but these kinds of conversations are happening because we've already heard the Attorney General say that they would appeal. The Attorney General's office says it will appeal against the case. So the lawyers would help us understand the intricacies of this whole, the complexities, and they'll try and break it down for us to understand. All right, so let me start with, in fact, let me just say that I have with four persons who are going to be doing justice to this topic. We have lawyer Apia Dankwa. He is a private legal practitioner, but a fan, a supporter of the movement for change. He's here with us. Good morning, sir. Thanks for joining us. Yeah, all right. That's lawyer Apia Dankwa. He's a private. Sorry, your mic was actually off. I'm told your mic was actually off. Right. Good morning, sir. Thanks for joining us.
Good morning.
Wonderful. And also, we're expecting to join us in the studio the Honorable Lawyer Inus Afuseni, who's also a private legal practitioner, who's a former Lands and Natural Resources Minister, and also former Roads Minister. We're expecting him to join us in the studio. And then also we have the Deputy Attorney General, Mr. Alfred Tia Yabua. Good morning, sir. Thanks for joining us. He's joined us digitally or virtually. That's via Zoom. Good morning, sir. Thanks for joining the show.
Good morning, my brother.
Thank you so very much for your time. So, whilst waiting for lawyer Inus Afuseni and Nanaya Jantwa, who is she's now the former General Secretary of the CPP. There's a whole drama happening with the CPP. Just this week, we heard that the National Executive Committee of the party has actually passed the vote of no confidence in her. So, she's no more the General Secretary. In fact, she herself says that she doesn't. She's resigned her position as the General Secretary of the party. So today she'll be joining us as the former General Secretary of the CPP. And so it'll be interesting to hear her thoughts on this. Now let me start with you, Lawyer Apia Dankwa. First of all, what are your initial reactions? I mean, when you heard that Aisha Huang, the Galamsey kingpin, and this whole talk about the fact that we're not really serious about, fighting the Galamsey menace, and that we've just been toying with this Aisha Huang's case, we've just been playing back and forth. We didn't look like we're really committed to making sure that she faced the full rigors of the law. And then finally, we've just heard that she's been jailed. And then this week, we heard that she's been jailed 4.5 years. She's supposed to pay $48,000 and so on and so on. What's your initial reaction to this news when it broke? And then also we can delve into specifics.
Yeah, so let me take this opportunity to wish your lovely viewers a good morning. I wish my own senior Deputy Attorney General good morning. It was a pleasure and privilege to share this platform with him. Share my other colleagues who would be coming, as Honorable Fuseni and my own sister.
Yunus Fuseni and Nanaya Jantwa and the Deputy Attorney General.
Yeah, I've wished him a good morning. They also a good morning, and then we expect them to join us soon.
Right.
So when I heard that the infamous Aisha Huang has finally been convicted, like most Ghanaians I was pretty excited. Okay. I was pretty excited that this lady that's dealt mercilessly with our environment, who's stolen our good resources,
right?
Who's disrespected Ghanaians and the country Ghana, finally has been caught in the grips of the law. And so, as all Ghanaians, I was very excited.
Okay.
As to whether that shows or lay credence to government's commitment to the fight against Galamsey, I think that's a conversation for another day, a conversation we are going to probably start discussing on this your show.
Right.
But I was really excited. I was really excited that Aisha Huang has been caught at least. As in the system has proven that if it's allowed to work, then people who offend the system, who offend the law, who steal from Ghanaians, would be or who and can be punished.
Okay.
So more, I was pretty excited. I know we'll delve into the issues that
the legal issues that are raising.
Yeah, but for now, let me leave it at that. That I'm pretty excited, and at least for me, is a clear example that if we are committed enough, then people who breach the law, people who steal from Ghanaians, people who disrespect Ghana, can be dealt with.
There are people who feel that it is not enough to whilst we wait to delve into the nitty-gritties of the law. But there are people who feel that if you jail Aisha Huang, you've really done nothing because she was working with a whole network. There are chiefs who gave her the land. There are persons who assisted her when she came to Ghana, perhaps immigration and so on and so forth. There's a whole bunch of other persons who have assisted, aided and abetted her activities. Why do we just go for Aisha Huang and leave the rest? I mean, if we don't deal with the root cause of the problem, or deal with the guys or the big boys who are behind these, or the activities of illegal mining, we're just scratching surfaces. We're just papering the cracks. We're not going to get to the bottom of it. We're not going to win the war. I don't know where you stand on this.
In fact, I think my position is pretty clear. I think, like I said, I don't think this shows credence that indeed government is committed to the fight against Galamsey.
I get that.
But let me say that at least we can't also say that government has or the state has done nothing.
Okay.
But it's a very small step as in this battle or war against
illegal mining.
Yeah. So yes, as in let's give credit where credit is due. As in it's not enough, but at least it's one.
It's a good start.
Yeah, is one small step, and then just to continue in giving government pressure. In fact, for me, in giving the president pressure, because ultimately he's a trustee.
Right.
Because if you read our constitution, it says that the president holds the minerals of this the minerals of Ghana as a trustee. You understand? So and continue to give them pressure in this fight against Galamsey. Like I said, and I keep on saying, if we are committed in fighting Galamsey, if we are committed in just enforcing the law, because really for me that's the issue.
Right.
The regime is there, the laws are there, the institutions are there.
Right.
All we need to do is to at least show a little bit commitment in enforcing the law and allowing the institutions to work. Now, once we do that, then this little step with Aisha Huang can lead to something big, can lead to ultimately the victory, as our victory against the menace of Galamsey. Was really is a massive theft being committed against the country.
Right.
Our resources are being destroyed. Our environment is being destroyed. The lives and livelihoods of Ghanaians are being destroyed. And it's something I think that we should take serious and should not allow partisanship to take away from us our ability to fight this one. So yes, for me, my view isn't that they haven't done nothing.
Okay.
My view is to look at the positive. You see that this is a small step at the fight against Galamsey, and hopefully we can all rally around the authorities. At the end of the day, this is a national issue.
Right.
For me, it's not a partisan issue.
Yeah.
We can all rally around the authorities, give them the needed support. They can criticize if it's necessary. At the end of the day, it's a war that we all need to fight and fight for Ghana.
I see. Now let me get again. Let's now get into the law because that is at the meat of this whole conversation, or at the center of this whole conversation. Now, again, we're talking about the new law as against the new laws against the old law against the new law. Now, so per the old law, due to the time that Aisha Huang committed the offense, she was sentenced based on the old mining law. Minerals and Mining Act 2006, Act 703, which imposes a maximum of 5-year jail term for engaging in illegal mining. Now, the old law, we're told, was replaced in 2019 by the Minerals and Mining Act 2019, Act 995. Under Act 995, convicted illegal miners will now face a minimum of 15 years in prison and a maximum of 25 years in prison. Now, when we're all privy to this information, why didn't you think people feel that the judge was lenient on Aisha Huang? When you read general reactions that people say, oh, it's 4.5 years, it's very lenient. Looking at the kinds of offenses that she's committed, try and help us understand whether, in your view, the judge did what she could do under the circumstances.
Yeah, so it is important to, first of all, say that the Act 703 was first of all amended in 2015, by Act 900.
Okay.
And it was assented on the 16th of December 2015. And the terms of that act, the maximum punishment that could have meted out to Aisha Huang was 20 years maximum.
20 years maximum.
Yeah, if you read, so I have the amended here. Amended the Act 911.
Right.
900 here. And it says that the principal enactment is amended by the substitution for section 99 of offenses and penalties.
Okay.
And then when you read the subsection 3, it says a foreigner who undertakes small scale contrary to the provisions of this act commits an offense liable on some.
Yes, I'm told that you're not speaking into the mic. So if you can just position it properly, exactly.
So let me read again. So it says a foreigner who undertakes small scale mining operations contrary to the provision of this act commits an offense and is liable on summary conviction to a fine of not less than 30,000 penalty units, and not more than 300,000 penalty units, or to a term of imprisonment of not more than 20 years.
Okay.
So it is necessary to appreciate or to understand that the Act 703 was first amended in 2015 by the Act 900, and then it was further amended, which was further amended in 2019 by the Act 995.
Right.
Now, second, it is also important to understand that...
Based on what you've just said to us, are you then suggesting that... So in other words, you're saying that the law on which he was charged was appropriate?
So you see, now the devil is always in the detail. So when you analyze the count, and there was one count, we say that she had committed illegal mining offenses from...
Yeah, she didn't have license.
From February 2015 up until 2017. That was the count.
Exactly.
Now, as of the February 2015, because we must understand that as to which law you would charge a person who has committed an offense or not would depend on when the offense was committed. Yeah, because it's fundamental that you cannot charge somebody under...
retrospectively or retroactively.
Exactly. So it would depend on when the offense was. Now,
at the time.
Yeah. Now, what she was charged with. She was charged for offenses that she purportedly committed. Right now, committed
in 2015.
February 2015.
Yes.
And 2017. I don't know exactly which month.
Right.
Now, so then you have a situation where there are essentially two regimes, more or less, that will govern when her
as in two legal regimes.
Yeah, because as of February 2015, the amendment wasn't in place.
Right.
So for the offenses that she committed on February 15th, February 2015, as in the regime and the punishment or the punishment regime was no more than 5 years.
Okay.
Now you have a situation where the offense continued up until 2017. At that time, the regime had changed.
Okay.
At that time, the regime had changed. So for me, personally...
So the states had a discretion to exercise. Whether to go for the 2017...
Is it a discretion? For me...
Or they didn't have any option?
No, in charging her. Because if she continued the offense up until 2017, for me, I would have thought that probably either you extend a count. Is just as an add another count. That says that let's say between 2016 and 2017,
Yes.
she committed, because indeed from what they are saying, she committed the Galamsey offense from 2015
Within a span of 2 years.
up until 20. So
Yes.
why, and probably that Attorney General is there, he can explain.
Right.
Because I would have thought that if really we want to exact the maximum punishment on her, then we could have done that by, let's say, one count. Between 2015 and 2016, she committed Galamsey. Between 2016 to 2017, she committed Galamsey. Then there wouldn't have been that confusion of, as in one offense, one count, falling under two regimes. Because you see, the judge, I think, made reference to Article 19.6
Yes.
of the 1992 Constitution.
Constitution.
Maybe we can read and then we can all decide.
Please do. Please do.
Because really, beyond everything, we're all educating ourselves too.
Exactly.
It says that no penalty shall be imposed for a criminal offense that is severer in degree or description than the maximum penalty that could have been imposed for that offense at a time when it was committed.
Okay.
Yeah, you understand. Now, for me, I feel that sometimes we can help in getting what we really want by minimizing, let's say, the confusion. And like I'm saying, the AG is here. Maybe he can help us and he understand what to do. But
get it.
I'm thinking that you could just have had a second count. That was that she committed the Galamsey offense from 2016 to 2017.
Right.
17. Then there would have been no ambiguity. It should have fallen squarely within
2016, between 2016 and 2017.
Should have fallen squarely in the act.
So that's why I raised the issue about discretion, which is that the Attorney General's office decided or elected to charge her based on the 2015 to 2016 laws, but then decided to ignore the 2016 to 20. I'm trying to see if I understand what you're saying.
So she did now pay the charge.
Yes.
She committed offense from beginning from 2015.
Yes.
And they say it continued up until 2017.
Up to 2017.
So in 2015,
Yes.
the regime was the Act 703, which had not been amended by the 900.
True.
You understand?
Yes.
So that was the regime.
And per that law,
But that
she would have been jailed for 20 years.
No, 5 years.
5 years.
Maximum.
Good. That's in 2015.
Now it continued up until 2017.
Yes.
So now so it means that she was still committing the offense
In 2017.
in 2016, 2017.
Yes.
By that time, the regime had changed.
When did the legal regime change?
It changed. So the law was assented to on 16th December 2015.
2015.
Yes.
So what it means, okay, so what it means is that there was a law before 2015.
Up until, let's say, 16th December 2015.
Okay, up until 16th December 2015.
Yeah.
And the law you're saying is 703.
Yeah, the 703. Yeah.
Good. And you're saying that the new law was passed in,
2015 December.
okay, so it only changed in 2019.
Then that law was amended
Yes.
in 2019.
In 2019.
Yeah,
Good.
you understand?
Okay. Now, the point you are making is that if in okay, so the under 703, per your reading,
Yeah.
it is possible for us to have made a case for Aisha to be jailed for 20 years per the law that
Per the 900.
per the 900,
But
which
then-
was promulgated when?
In 2015, December 2015.
Okay, so before, hold on, because I want to be clear about something. When did 703 end?
So 703 hasn't ended.
Oh, 703 hasn't ended.
No, it's just been
It's only
amended.
been
So
amended.
portions of it has been amended.
Okay, so there's a portion. Okay, so there are aspects of 703
That has been amended.
in
900.
In 900.
So what 900 did
Okay.
was to amend certain portions of,
703.
among other things, the penalty, as in the crime and penalty.
Right.
So in 2015, it was amended.
Right.
You understand?
Good.
Then in 2019, it was further amended.
Okay.
You understand? So what the 2019 amendment simply did was to say that the minimum was to add, let's say,
Make it 20 years.
and said the minimum was 15, the maximum was what's it called? 20.
20.
The 2019 and then the 20 didn't give a minimum. It just said a maximum punishment of, as in you should not be punished, or the maximum punishment that can be meted out to you in per the 703
Okay.
was 5 years.
5 years.
Per the 900 was what's it
20
called?
years.
20 years. And then the 2091 did that added a minimum of 15 years and a maximum of 20 years.
I get that. I get that.
You understand?
I get that.
Now, the issue is, per what she was charged with, because then the count said that count one, as in Aisha Huang was charged with
Right.
offenses that she committed between February 2015.
Okay.
At which time the maximum punishment she could have been given was 5 years.
Was 5 years.
Up until 2017, so it was
It had
a
changed
continuum.
because it had been amended.
No, but it was so the
get
charge
it.
was continued. So they were charging her for offenses that she committed from 2015
Okay.
to 2017.
I get that.
Yeah, you understand.
I get that.
But within that period, there were
Yes.
two regimes.
Right.
Within that period,
Yes.
2015,
709 and 900 combined.
703.
703, 900 combined.
So in February 2015, the regime was 703.
I get it.
There was
I
no
get it.
amendment at that time.
Let me go to the
Yeah.
Deputy Attorney General to try and help us understand this. John Alfred, I'm sure you've been monitoring the conversation between myself and Lawyer Pierre Dankwa. Is there any clarity you can bring to bear on this? Because there's a certain thinking, or there's a certain sense that you chose to apply certain laws, which has actually culminated into Aisha Huang being jailed 4.5 years, whereas you had other options. Help us understand, help us understand this.
Thank you very much, my brother. And let me also say good morning to my learned friend in the studio and other viewers of Metro TV. Now, I've listened to him carefully, and I think he's making the conversation very interesting. Let me also take viewers through the law. But my friend has made mention of Act 703.
True.
Now, this Act 703 was amended in 2015 by the passage of Act 900. Then subsequently, there was an amendment to the Act 703 by Act 995. In this particular case, in Aisha's case, the offenses took place between 2015 and 2017. My learned friend has made reference to Section 3 of Act 900, which deals with foreigners engaging in small-scale mining. My emphasis, small-scale mining. Now, if you go into Act 703, under definition section of that Act, Section 111, small-scale mining has been defined. And it's been defined to include working on at least 24 hectares of land. So before you can charge any foreigner for engaging in illegal mining under Section 3 of Act 900, there must be evidence that that foreigner worked on a prescribed land of at least 24 hectares. 24 hectares, by my calculation, is close to 60 acres of land. And so if you arrest a foreigner and you cannot get evidence that the foreigner worked within that prescribed area of at least 60 acres of land, and you go and charge that foreigner that law, you lose. Because the essence of that section is to ensure that foreigners do not get themselves involved in small-scale mining, but large-scale mining. So Aisha Huang was not charged under Section 3 of Act 703 as amended by Act 900, but rather under Section 2 of Act 703 as amended by Act 995. Let me also place on record that Aisha Huang was not charged under Act 900, because that act was repealed by Act 995. So she was charged under Section 2 of Act 703 as amended by Act 995. In terms of the suggestion that my learned friend made, whether we charge some part in 2015 and some part in 2015 and 2017, That one didn't arise because she was not engaging in small-scale mining. She was engaging in illegal mining operations because the evidence that we had was that Aisha will go to you, get 1 acre of land or 2 acres from the cocoa farmers or the farmers, she'll buy the land, go somewhere, get another half acre, 2 acres, 3 acres. So her operations was not about small-scale mining. And so that's the reason why that section does not come in. If we had gone under that section, I can assure you that that's a very big challenge. And so as prosecutors, we draft our charge sheet looking at the evidence available to us. Also looking at the law that we have in our statute books. So that portion about having a minimum of 20 years does not arise because she was not charged under that section. But that section was not applicable. I can just, maybe my learned friend may want to go and look at the interpretation section of what constitutes small-scale mining. So that's the basis upon which she was charged and engaging in illegal mining operations without license, which does not make reference to whether a foreigner or a Ghanaian. Whoever engages that act should be punished under that section. Now, if you look at Act 703, then Act 900, there's this introduction of small-scale mining in the punishment under that Section 3 that my learned friend read. But if you go to Act 995, that section which deals with small-scale mining has been taken away because it was posing a challenge. Because you get people who are foreigners who be engaging in mining, but that does not constitute small-scale mining. So now the law in Act 995 does not make mention of small-scale mining again. It talks about illegal mining operations. So that's the reason why Aisha Huang was charged under Section 9(2) of Act 995 as amended. So that's how, my brother, it works. When it comes to the punishment, under Act 703, the punishment was that it be in prison for up to 3 years. Then under Act 900, which amended portions of 703, engaging in illegal mining operations, the maximum sentence up to 5 years imprisonment, maximum fine 3,000 penalty units or both. And so, even though Aisha Huang was charged under Act 995 of 2019, which is the appropriate legislation to charge Aisha under, when it came to the punishment, because of the constitutional injunction under Article 19(6), the judge then said she had to use the maximum sentence allowable in 2015 to 2017, and which was 5 years imprisonment. So my initial thoughts are that Aisha Huang was charged under the new legal regime, Act 995, but was punished under the old legal regime, basically because of the constitutional provision in Article 19(6) of our Constitution. That's what the judge said. Now, this issue came up in court. Lawyers for Aisha Huang raised an issue. Then even charging her under the new regime was not proper because the offense was committed before the new regime or before Act 995. They raised that objection. When they filed solution of no case, they raised that strongly legal point that because of that, Aisha Huang should be acquitted and discharged. Then they also raised the issue that if you look at Act 995, there was no savings clause. I think my friend understand that one. Maybe if you say savings clause, it means that when we repeal an existing act, you may want to insert a clause in the new act, saving some provisions in the old act so that the old act can be applied in the new act. Counsel for Aisha Huang raised the objection that the new Act 995 did not save any portion of Act 900. So we had to also respond. And thankfully, we have to fall under Section 34 of the Interpretation Act, 34(1)(b), which is the effect that if a new act has repealed an old act and does not make provision for savings, any offense committed under the old act will still continue to be applicable under the new act. Then also this Supreme Court decision that determined that matter, I think Edmond, I don't know the full, I forgot about the full title, the first Edmond, Supreme Court also resolved the same by saying that if an act is repealed and the new one does not save any provisions, it is implied in the new act that the punishment or the offense committed under the old act can be still prosecuted under the new act. So that's the reason why we succeeded on that objection raised by counsel for Aisha Huang. So in terms of this particular case, a lot of legal issues have been resolved in it. Judgment, we can go through the process and we'll to understand better how come the judge came to that conclusion, the opinion of the judge in this particular matter. So in terms of charging Aisha Huang, she was charged under Act 995, which has amended Section 7, which has amended Act 703, but the punishment was exacted under Act 900 because that was the existing punishment at the time that the offense was committed. And we were able to charge her under the new act because of the explanation I've just given, because of Section 34 of the Interpretation Act and also the decision of the Supreme Court in that particular matter. We sought to interpret where a new act has not saved an old act, what would be the circumstance.
Wow, this is what we call it, is a matter of law. But there's something that there's something that I need some clarity on, and please pardon us, we are mere mortals. We're not members of the bar. We're not lawyers, and so pardon the ignorance that we may express as far as the matters of law are concerned. But here's the thing: you said in your explanation, in fact, in your education to us, that because of the constitutional hurdle, you couldn't have punished Aisha Huang based on a law which had been repealed. Or you couldn't have punished her based on a law which was enacted post facto, which is after she had committed a crime. So help us understand how you reconcile the new law which has been passed, based on which she was handed a sentence as against the law which was charged. I mean, that portion is what I'm not very clear about. If you can come again.
All right, thank you very much. Let me just explain myself again.
Okay.
If there is an old law and there is a new law which has repealed the old law.
Right.
If you committed an offense under the new law and you're to be prosecuted, you cannot be charged under the old law because that law has effectively been repealed.
True.
You'll be charged under the new law because that's the existing law. But when you are pronounced or found guilty, and when it comes to punishment, per our Constitution, Article 19(6), the judge cannot punish you more than the punishment that existed under the old law.
Oh, I get it.
However, if you take our Interpretation Act, Section 35, 2E, if the new law has reduced the punishment under the old law, then by that one, the person will have to be punished under the new law, but not the old law. So if the new law has reduced the sentence, the law is saying that don't go back to the old law. Use the lesser sentence to punish him. But if the new law has enhanced the sentence, the law is that you must go to the old law to punish such a person.
But what's the philosophy driving this? I mean, sorry, we're digressing a little bit because I'm trying to understand the thinking that went into this. Between 2015 to 2017, arguably, the law at the time was maximum 5 years. The new law, maximum 25 years?
25 years.
25 years, the new law. Now, you're saying that per the Interpretation Act, we couldn't have punished her more than the 20 years, which the new law says. You must go back to the old law because the old law actually exacts lesser punishment than what the new law is saying. I'm trying to understand the thinking or the legal philosophy that went into that. Means, sorry. I'm trying to get to take us to the law to the law class. But what's the thinking? Why is it so?
Yes, when it comes to criminal prosecution or when it comes to criminal jurisprudence, the thinking is that the accused person must always be protected. And for that matter, if there is something new which will be to the benefit of an accused person, let him enjoy it. But if there is something new that is to the detriment of the accused person, then don't let him suffer that one. Take him back to the time that he committed that offense.
Right.
And so in our constitution, we made an explicit provision that if you are punishing an accused person for an offense, don't punish him more than the offense, or don't punish him more than the sentence at the time that he committed the offense.
Yeah.
Yes. But as I said, but if the new regime has reduced the sentence, then don't also go back to the old regime that is hard or that's harsher, but use the new regime that has reduced the sentence. So that's the thinking around the trial of accused persons, the criminal trials and the rest. That is the process, and that's the position as we have it.
Wow. I think our criminal jurisprudence is very interesting. Well, I'm not a lawyer, but I hear my friends talk about criminal jurisprudence, and it looks like it's a very interesting area of study for persons who are aspiring to become lawyers. But let's now make progress after walking us through the legal regimes that is actually informing the final decision or judgment by the court. So after this explanation, it then makes nonsense of the argument that the punishment was very lenient.
If you are to look at what we have now, you'll be tempted to say the punishment is lenient.
Yeah.
Because what we have now, the minimum sentence for a foreigner who engages in illegal mining operations is 20 years.
Okay.
But we cannot say that the judge erred by giving Aisha Huang 4.5 years, because that is what the law enjoins her to do. But I also not fault people who may want to say that because that is there, but that one too doesn't mean that the judge should just come and say she's going to use a new law, unless, of course, which we are seeking to do, to see if the constitutional imperative or the constitutional provision Article 19 could be on appeal, which may eventually even go to Supreme Court interpretation to see the import of 19.6 vis-a-vis a new legal regime. It's a gray area that we may want to explore. So within the week, you raise statement about the Attorney General trying to appeal or wanting to appeal. We are not saying that the judge actually had it is wrong though, but we may want to explore the possibility if looking at Article 19.6 and putting proper interpretation on it, an accused person charged under a new law should be made to face the punishment under the new law. As we speak, there's no pronouncement on that. So in that case, the judgment that the judge has delivered is the position of the law now.
So what it means is that we may have to go to the Supreme Court to seek some further interpretation or some further clarity on this. Because like you said, you have already hinted that you intend to go to court to appeal against the case. In fact, I've heard some people say that shouldn't be the route, and that press new charges against her and now prosecute her based on the new law. So the two schools of thought. I don't know where you stand on this. First of all, whether you think that at some point somebody may have to go to the Supreme Court and get some clarity as to whether the appeal process would whether it's even justiciable, and then of course, the other opinion being expressed, which is that forget about an appeal, press new charges and take her to court.
Yes, we pressed this or we brought these charges against her based on the new law. I want viewers and listeners to take note. We never charged her under the old law.
Oh, I get it.
We charged her under the new law.
Okay.
It was only the punishment that was exacted
Under the old law.
The old
I get
law.
that. I get that.
So going to prosecute it again is not something that we may have to look at.
True.
The option left is to see whether there can be a legal engineering through the court processes to see whether a careful reading of Article 19.6 should suggest that an accused person, when convicted, must still be punished under the old law or the new law. If in the course of the trial, we had received evidence to the effect that Aisha Huang, on her return to Ghana last year, continued to engage in illegal mining, we'll have charged her under the new law once again. And if we had secured conviction, then we'll have had the new punishment being exacted on her.
And all of this you're saying is regardless of whether she's a foreigner or not. I mean, if a Ghanaian was engaged in mining, of course, we are allowed to engage in small-scale mining, of course, with a license, if you're licensed to do so. The foreigners are not allowed. So I'm saying that if it were a Ghanaian who was engaged in mining, whether small-scale or large-scale, without a license, this same law would have applied?
This same law would have applied.
Okay.
If, for example, a Ghanaian was charged with engaging in illegal mining operations in 2015 or 2016, and he was arrested in 2020. In charging that Ghanaian, we charged him under the Act 995, which has amended Act 703. But when it comes to punishment, the judge, relying on Article 19.6, will fall on the old law to punish that Ghanaian. But what we have done now, apart from Aisha Huang's case, is that all those who have been prosecuted were people who were arrested after 2019, and those offenses that they are facing now were committed after 2019. In fact, last year, if you remember, some Chinese nationals were also sentenced into prison custody in the Western region by a court. And that court, in sentencing them, used the old law to sentence them, even though they committed the offenses after 2019. When the judge gave that judgment, we also filed an appeal to challenge that decision, and we won. And as we speak, those Chinese nationals are in prison, serving over 20 years IHL. So Aisha's case is because she committed the offenses before 2019. That's how come the court also used the old law.
Okay. Other issues have come up, and two key issues have come up, and then I'll come back to my resource persons in the studio, and then you'd have the opportunity to respond to some of the concerns that were raised or some of the points of disagreement. But I've heard some people say that, of course, you're not an investigative body, you prosecute. But let me pick your opinion on this. Why do we focus on Aisha Huang when there are very influential, powerful person? It's a network. Somebody definitely gave the land to her. Somebody facilitated her re-entry into Ghana, and so on and so forth. We don't seem to be interested in going after these persons. We seem to be jubilating over dealing with a symptom, if I mean so to speak, and not dealing with the root cause itself. Is this something that Attorney General's Department is also concerned about? And I don't know what you can do about this, but I'm sure you've heard that conversation within the public domain that let's go after the people who have abetted and aided Aisha Huang in doing what she did, or in engaging the kinds of activities that she's been engaging in. You know, must we, for instance, I haven't seen a new law, and I've got to confess, I've not read the new law, but does the new law, for instance, take cognizance of some of these actors and how to deal with them in order to serve as a deterrent, punitive enough to serve as a deterrent, so they don't assist or they don't assist anybody who intends to engage in this kind of illegal enterprise?
Yes, I've heard this argument. We are also very much interested in getting those big fishes or those who aid and abet the commission of illegal mining operations. But I've always insisted that we rely on the evidence that we have. In fact, in Aisha Huang's case, 6 out of the 11 witnesses are actually farmers.
Okay.
And farmers who gave their small parcels of land to Aisha Huang to engage in illegal mining operations. But we use those farmers as prosecution witnesses. But for their involvement in the prosecution of this case, we couldn't have succeeded in prosecuting Aisha Huang, because she denied flatly that she never engaged in any illegal mining operations. But those farmers from Bipotintin and other places were brave enough to come forward to explain to us how they met her, how they were able to negotiate with her, so that she could take over portions of their land to do illegal mining operations. And so, apart from these farmers that we use, we do not have any other person who also facilitated the commission of that crime. We could have chosen to also perhaps prosecute those farmers for abatement of crime, but that would have meant that we didn't have had any evidence to prosecute Aisha Huang. And in terms of criminal prosecution, if you want to nail some of the accused persons, you sometimes have to sacrifice others. And let me commend the farmers. And the reason why we are where we are today is because people are not ready to talk. Because if you threaten that farmers who have given 1 acre, 2 acre land to people to engage in illegal mining are also to be arrested and prosecuted, all of them will keep quiet. Nobody will talk. They will all deny the charges. And we may not have any direct evidence nailing those people engaging in illegal mining operations. So I agree. All those who are complicit, if we get evidence, why not? But as we speak, there are other Chinese nationals who are also facing prosecution in the same court. We also have Chinese nationals and other foreigners, I know Vietnamese and others, who were also part of the cabal, and they are facing prosecution. But in terms of entry into Ghana, if we get any evidence that shows that any individual facilitated her illegal entry into Ghana, we will deal with that person in accordance with law. It's only Aisha Huang who has been dealt with. If anything comes up, we go after such people.
Let me, in fact, I'll come back to you with the issue of the other cases that the Attorney General is expected to be pursuing. And let's talk about Akunta mining. I'll come back to you on what's the state of our quest to get to the bottom of the legal infractions, to speak of Akunta mining. We do know that the likes of Ken Ashigbe, lawyer Martin Kpebu, and so on have actually petitioned the CID to look into the activities of Akunta mining and then pass the docket to the Attorney General's office to look into it, and so on and so forth. So I'll come back to you and find out from you what you know about the status and the extent to which the Attorney General's Department has been following up to find out what has been found out by the CID and see whether it's a case that can be prosecuted in court. So I'll come back to you to find out what you know about that. But let me say that the former General Secretary, it sounds a bit awkward, doesn't it? because we always introduce her as the General Secretary of the CPP, but just 72 hours ago, 48 hours ago, she ceases to be the General Secretary of the CPP because she says she's sick and tired. She wants to leave, and that was after the party itself, well, not the party, but a group that calls itself the National Executive, Committee of the party said that they had passed a vote of no confidence in her. But Nana Ajantwa is still here with that. One thing you can't take away from Nana Ajantwa, she's very passionate about this country. She's very passionate about Ghana. And so I wasn't surprised when she said she can serve Ghana in different capacities. She doesn't necessarily have to be the General Secretary of a party that was formed by her father, and she loves the party, and so on and so forth. Nana, it's good to see you. Good morning.
Good to see you.
How are you?
I'm fine, thank you.
I mean, I was totally surprised when I heard some of the things that were said about you, because I've known you for many years, and
yes.
I was wondering what's happening.
Yeah.
You know, what's happening?
Yeah, I don't know. Let me say good morning to you, good morning to my brother.
Yeah.
And good morning to your viewers, and good morning to Ghana. I was surprised myself. We were just going for a NEC meeting, and it came up that they said they passed a vote of no confidence. I was a bit surprised when I saw this vote of no confidence, because nobody voted. Because if you say vote of no confidence, then it
means voting has taken place.
Somebody mooted the idea that we don't want you as a team.
Right.
Then you say,
let's
vote.
Let's cast a vote.
Let's cast a vote and see. So if like 50, 60, 70, 80 in favor, not in favor, then you say that a vote was cast.
Makes
it was
sense.
just on top of everybody's voice, go, those things. So me, at a point, I just realized that after everything that I've done, all the insults that I have endured, telling me that I'm a fool because I don't have a husband. And
someone said that?
Yes, exactly.
How petty and low we can get?
Yes, yeah.
Wow.
And that I don't have sense because I'm not married, and that I'm senseless, I'm a good for nothing person, and all those. Yes, as I went on TV, I always imbibed all these, and I needed to put up a good face, and because I love the party.
You mean you had this being said by somebody, or it was just
It said to me. I was sitting there, and it was told to me in my face. They could even use my body frame to insult me that I'm a hunchback.
See.
Yes. So I'm evil.
Who's this person?
It's all I've left, but I mean these things. I'm evil. I'm the problem of the party. So if I'm a problem of, so when I saw all those things going on, I said, well, how? What the heck? I might as well leave. I've endured all this. I've spent my money on this party. I've spent my time on this party. I mean, I've tried to make this party very visible in the eye of the Ghanaian. And if this is what it is, I mean, let it be.
Like we say, it's a papa here.
Yeah, I paid
time to move on.
Party rent. Even in Kumasi, I went to Ashanti region, my region, to pay the rent for the party office.
Right.
So I've done giving the party motorbikes, other logistics, photocopiers, I mean, all manner of things.
Okay.
I mean, paying school fees for party members, helping them out here and there. I don't have much, but the little that I get, I give it out. And even now I'm in debt.
Right.
Because sometimes I even borrow to give people in the party and doing party work. Every event on the party calendar, I get money. Sometimes I borrow. All that. One day I noticed that my bank account is empty because I kept taking money without even, taking notice, or because I was using it for the party. But if that is what it is, maybe you have to shift on to Galamsey.
Right, that's fine. We'd have some time to discuss this. But what's your initial preliminary remarks when you heard about Aisha Huang? Finally, she's been jailed.
I am happy that I noted the question you asked the minister.
Okay.
That's why is it only
Chinese
people and Vietnamese who are being jailed and prosecuted and jailed.
Yeah.
And besides, somebody also allows them to enter the country.
True.
At the immigration, when you travel anywhere, they ask you, what are you coming to do in this nation? True. If you are going for a conference, they give you a letter. Mm-hmm. You show it to them that I'm coming for a conference.
Right.
If you are going for an attachment, they give you a letter.
Yeah.
To show that you are going for attachment. I remember I was going for an attachment. I think it was a PRC or Free Zone, so one of them. I was going for an attachment at RIPA. Royal Institute of Public Affairs in the UK. And I came and I said, oh, I'm here to, you said do what? This was like a work exchange program.
Right.
So I'm here to, be with the RIPA, do some experience and work. They said work. Then I noticed that I didn't say it properly. So I showed the letter to them and they noticed that it was an attachment.
Right.
So even that one gave me a little bit of a problem there. So I'm wondering what they ask these Chinese people when they come to the immigration. And sometimes they come in droves. So how do we allow them? Are they coming for tourism? Are they coming to get married? Because I know some of them come and get married and have kids.
Right.
Take one child away and leave the rest here because the states will not take care of all the children. So what are they coming to do? And I think that our immigration service has failed woefully because they allow these Chinese people, whether through the land borders or sea or air, they are there to find out what they are coming to do.
Right.
Number two, I think one key group of people that the nation should target are the landowners.
Right.
Because if you don't sell land to me to do Galamsey, I cannot do it. I cannot steal. I cannot encroach. So the Lands Commission has the title deeds of all people. Unless I am wrong, somebody should correct me. When you own land in this country, you need to register that land because otherwise you can't use it for anything. So who are those selling the lands for Galamsey?
Right.
It is very important that we look at it. We look at the person who sells, the buyer, and even the person who is doing the extraction, the execution of illegal gold.
Right.
And it is key if these people really want to fight Galamsey. When you talked about the big wigs and the minister was talking, he averted his eyes. So I was like, why is he all of a sudden he averted his eyes upwards? And he said big wigs. It's as if something was going through his mind.
Right.
So I was wondering, why is he averting his eyes like that? So maybe he knows that because, for instance, even if he is not aware, Professor Frimpong Boaten's report gave up some names. Have they investigated?
Right.
Have they found out? Because if you really want to fight Galamsey, there are so many ways you can fight Galamsey.
Right.
The excavator they have been burning, it has a chassis number. The chassis number will lead you to who owns this car. Because when you are registering your car or you buy the car, the chassis number is key.
True.
So why do you burn it and don't look for the chassis number to locate who owns it? Because even if it has been rented, somebody owns it.
Right.
And somebody bought it from that owner or rented it from that owner.
True.
So that will lead you to whoever is using that. But you burn it. And he is a lawyer. Do you get me? And that is key evidence. The chassis number of all of these equipments they are burning, you have to use it as an evidence, as an investigative tool.
Right.
If you jail Aisha Huang after so long, she goes, he comes, she goes, he comes, and eventually, as if to appease us, you have jailed her. Right now, Ghana even wants to do a debt exchange with China. What if China comes and says that you have jailed one of our people? She's a businesswoman. I hear she's influential in China.
Yeah.
And they use it as a bargaining chip.
You remember what Osafo said?
Yes,
Yeah.
yes. What will you do? So you have to go after everybody who is doing this to us. Look, when I came in and I saw this, I thought that we are back into slave trade. This looks like an epitome, an exaction of slave trade. Look at people in a pit. Look at this young man. So this young man is a key evidence to whoever owns this site.
Right.
The police can zoom in and find out who he is and arrest him as a key witness.
Right.
Do you understand me? The farmers who were key witnesses should have been arrested themselves and prosecuted, because if you are you can be arrested, prosecuted, and maybe given a lesser sentence.
Okay.
But not to go scot-free because they sold their lands to Aisha Huang. If Aisha Huang and the likes of Aisha Huang, when they come into this country and they don't get the land, they will go back.
Right.
So the buyers are the sellers are as guilty as the buyers.
Right.
So if somebody has sold their land to do Galamsey, and you say that you use them as a witness, otherwise you would not find. Who doesn't know that Aisha Huang is a Galamsey person?
Okay.
Did you get me?
I get it.
Number two, the slave master standing there, he has a chair. Look at him, his profile can be picked. because he's superintending over slavery. He's superintending. This is dangerous. These are young men who should either be in some form of fruitful venture, maybe should be in school at the SS level, tertiary level, or learning a trade. Look at where they are.
Right.
And this Galamsey that they are doing, it is not definite that you find gold. You have to scratch and scratch and scratch. And there can be some eruption, a volcano, and all these things all these people will be buried down there.
Right.
Losing our human resource to such criminality and illegality. Look at how the man is standing there supervising this deadly act.
Yeah.
And nobody, so this man standing there, is he Chinese?
Right.
I'm asking, is he Chinese?
He's Ghanaian.
He's Ghanaian. Look at him, his
Ghanaian.
profile.
Yeah, he's Ghanaian.
So the police cannot profile this man and go for him.
Right.
This is key evidence. My brother, you don't have to turn. He's here. Look at him. And he's there. Because such a person is key to whatever is going on. And you let them go scot-free.
Yeah.
Names have been mentioned. Names of big men have been mentioned. Nobody is doing anything. They are always going after the Chinese.
Right.
Because the Chinese, they cannot understand anything. They neither speak Chi, Ewe, or Fanti.
Right.
They don't even speak English. So they don't even know anything. There are a lot in their country. When you go, there are plenty. They want to find a place to put them. I remember Rawlins's time, they used Chinese prisoners to build the National Theatre. So they want a place to load them. So they come in droves and come and work on these areas. Do you get me? So for me, they are the vulnerable end of the tail.
Right.
Do you get it? They are the vulnerable end of the tail. They can't speak English. They don't understand anything. When they come, okay, they boss it over people, but they don't understand. And when you see them, they are level in China. They are very low down there. These are the people they bring here.
Right.
So if you target those ones, Aisha Huang, for instance, yes, she might be a high-class spy or something. But you can see that she is not any sophisticated, intelligent person. Do you get me? So, if you are always going after the foreigners, what about your own? Using the Galamsey, destroy our forests, destroy everything, and using the money for political campaign. Because you see, these days, you cannot go and steal money like stealing government money. Everybody is looking at you. So this is the source of people or politicians, some of them using it to get money. And there's a lot of money in there. Because you see, $6 million worth of illegal gold is leaving the shores of Ghana to countries abroad. Look, I have a friend who lives in Dubai. He's an Arab. He's from the Emirates.
Okay.
And he told me, he said, look, Nana, we have more gold than you have in Ghana, but we don't have gold in the Emirates. The gold that is coming to the Emirates and what we have is more than you have in Ghana. Why? Because we are exporting illegal gold, and we will go to IMF and struggle and ask for $3 million. That they are even bluffing us. That's even the second tranche is forcing its way to come through. But meanwhile, we have gold that is exported illegally. And it is the same thing I am asking. It is being exported illegally through which avenue? The same way the Chinese people are coming in. The same way our illegal gold is going out. And this kind of business is not for these young ones who are in there. So when they go and arrest them and put them into police station and prosecute them, it is laughable. Because these young ones, look at this boy. Has he got the capacity to export illegal gold? As he stands there, even because he doesn't even know what he's doing is wrong. He has posed for a picture.
Right.
When you look at him, he has posed. Do you understand? Yes. Right. So the illegal gold that even leaves our shores, who is taking it away?
That's a question for the courts. Let me just say that the Honorable Yusuf Hussein, who is a former Minister for Lands and Natural Resources, couldn't join us physically here in the studio, but he has actually accepted to speak to us via phone. The Honorable Yusuf Hussein, good morning. Thank you very much for accepting to join us on Inside Pages.
Good morning, Umar, and let me apologize to you for not being able to join you in person.
Right.
I'm far away in the northeast region, and I was not able to catch the bus to get to Tamale and then join the plane.
That's fine. That's fine. I mean, you are somebody who doesn't disappoint. And so when this morning we didn't see you here, I knew that something genuinely has stopped you from joining us. And so I can totally understand where the explanation. Right.
Thank you for your understanding. Thank
you. Sure. So we're having a conversation which has to do with an area that you have vast knowledge in, which has to do with Galamsey, or small scale illegal mining. And the High Court's decision that it made on Aisha Huang, 4.5 years, pay 48,000 after serving your jail term, were deporting you to your country. What are your initial thoughts? What are your initial reactions to this?
Well, Umar, I was just listening to Nana Jantua, and she raised some very interesting points. But then the High Court's decision is baffling as well as troubling. And I have said on several platforms that I would love to hear the concluding or read the concluding remarks of the Attorney General. Now, the history of mining, and particularly after the 1992 Constitution, starts from from the Rawlings era and the promulgation of Act 703. Now, the Act 703 was subsequently amended by Act 900. Then Act 900 amended by Act 995. Now, the relevant section that Aisha Huang was sentenced or tried under was Section 99 of Act 900. Now, we will look at the minerals and mining law, especially for small-scale mining. It is only a Ghanaian who can mine, and that Ghanaian must mine pursuant to a license, a permit. So if a person mines without a permit, then that person commits an illegality. That is, if a Ghanaian mines without a permit, it's an illegality. Now, because Act 703 totally and absolutely forbids a foreigner, a non-Ghanaian, from mining, that non-Ghanaian cannot even apply for a license, let alone coming under the contemplation of a Section 99, Section 99, 1 or 2. Because that person, that non-Ghanaian, cannot apply for a license. That is why when you look at Section 9, Act 900, the Minerals and Mining Act as amended 900, Section 99.3 deals particularly with foreigners. Now, if you have that act, just read that act, that provision 99 subsection 3. It says a foreigner who engages in small-scale mining. You don't need to add without a license because a foreigner cannot take a license. Will be sentenced, when arrested and convicted, will be sentenced to 30,000 penalty units or 20 years in jail. That is Section 99.3. So if the Attorney General says that because of the constitutional requirements and the fact that the offenses committed by Aisha Huang were committed in 2015 and 2017 when Act 995 was not enforced, Act 900, which was enforced then, made provision for dealing with a foreigner who engages in small-scale mining. Because you can't take a license. A foreigner cannot take a license. In fact, a foreigner cannot even provide mine support service to a small-scale miner. So I fail to see how the Attorney General rationalizes his satisfaction with the decision of the court, and why they did not canvass on the court the relevant provision of the law, and that is dealing in small-scale mining under Article 99, under Section 99.3. I mean, I'm yet to listen to their or understand the rationale behind the clear avoidance of the effect of Section 993 on the sentencing of Aisha Huang.
Okay, would you want the Deputy Attorney General who's been with us via Zoom since the start of the show, because he's listening in and he says he wants to quickly respond to the question you've asked. Would you want him to respond to it before you move to the other aspects of the case?
Yes, I want to hear what he will.
Fantastic.
What he will say.
So Honorable Alfred Yabua, what's your response to the Honorable Indus Hussaini?
Thank you very much. Now, good morning to my learned senior and the former minister.
Thank you.
Now, he's mentioned Section 99(3) of Act 900.
Yes.
Which deals with foreigners engaging in small-scale mining. So the key question is, what is meant by small-scale mining? So let's go to the Act 703 that has defined small-scale mining. Now, small-scale mining operation means mining operations over an area of land which is prescribed in blocks. And let's look at what's meant by blocks under the same Section 111 of the Minerals and Mining Act. Block means 24 hectares. So before you can charge someone for engaging small-scale mining, there must be evidence that at least 24 hectares of land. So the question, we have evidence that Aisha Huang dealt in land of at least 24 hectares of land. And that's the very reason why if you take Act 995, they deleted that portion dealing with small-scale mining. Otherwise, most foreigners may escape. So in the circumstance of this case, Aisha Huang was dealing with the farmers, some of them 1 acre, 2 acres, because 24 hectares per my calculation is close to 60 acres of land. So we didn't want to take a risk where we don't have the evidence. We charge her under that section, you go and you fail, because we prosecute based on the evidence that we have. So that's the reason why, if Malene Senior may want to know why we didn't go under that section,
so
99(3), because of the definition ascribed to small-scale mining under the Act 703, but rather we use the prosecution under Act 995. Let me repeat. We prosecuted Aisha Huang under Act 995, which has amended Act 703.
Okay, help me understand something.
And we prosecuted under Section 92.
Right. When you amend an existing law, does it automatically declare the law which has been amended null and void? Do you get it?
That's why earlier, yes.
So
it does.
If there is no savings,
okay,
there's no savings, and someone has committed a criminal act under the old regime,
yes,
then by the Interpretation Act, Section 34, that person can still be prosecuted under the new act.
Okay.
Despite the repeal of the old act.
Okay. All right.
So we were able to prosecute Aisha Huang under the new act because of the provision under Section 35 of the Interpretation Act.
Okay.
All right. And also because of the Supreme Court decision in Edmond, which will effect that if an act has been repealed, it does not wipe away the offense committed under that act. And for that matter, even if there's no saving clauses in the new act, you can still prosecute that person under the new act. It's only the punishment that now there's an issue about the constitutional injunction and the rest. So to answer my learned senior and former minister, if you look at the interpretation given to that was quite problematic, and there was no way we could have gone under that section.
Okay, Honorable,
again?
Okay.
I've listened to the learned Deputy Attorney General, and I think that there is a fundamental error. The mining regime is classified into 2 sections. Well, we have 2 types of mining regimes. We have the large-scale mining, and we have the small-scale mining. Was Aisha the one doing large-scale mining, or she was doing small-scale mining? She was collaborating with Ghanaians and taking their 1 acre, 2 acres, 5 acres, 50 acres. Was she doing large-scale mining or small-scale mining? That's the first thing. 2, the law says a foreigner, a non-Ghanaian, in fact, Act 995 even makes it clear, because we had thought that when we are amending Act 900, we thought that a foreigner is derogatory, and so we should say a non-Ghanaian, to put it in contradistinction with a Ghanaian who can engage in small-scale mining. So it becomes abundantly clear that if you are a non-Ghanaian, you cannot engage in small-scale mining. Yes, small-scale mining is defined in parcels and blocks. But do we have middle-scale mining in Ghana? No, we don't. And I thought that as the Ministry of Justice and the Attorney General's office determined to fight the dangers that small-scale mining has exposed this country to, would have looked for the evidence and prosecuted, because you wanted to send a message. You wanted to send a deterrent message to the others who were engaged in small-scale mining, whether foreigners or non-Ghanaians or Ghanaians, and to have been satisfied with a 4.5 years sentence and a 48,000 Ghana cedi fine, which is less than $4,000. Less. Amagento just told you that people export up to 6 million worth of gold from the small-scale mining sector. And the reason why the Act 703 was amended in the first place, in particular reference to the sentencing regime, was that we thought that it was so mild. And at that time, it was only a fine. And we thought that it was so mild that non-Ghanaians who were engaged in small-scale mining, illegal small-scale mining, could simply walk to the registry, pay the fine, and go back to the mining site, because they were getting more than they were being punished for. And so you wanted it to be deterrent enough to put them in jail, as well as take high fines from them. And for the Attorney General not to say that, well, because they didn't have evidence that she was doing small-scale mining, so had to go to a person, which is 99, in the sentencing regime, a person. Now, but again, that's a constitutional issue. So now that the is on the line, I would like to understand, and that's a constitutional issue, I would like to understand the basis upon which, having prosecuted the Aisha Huang on 995, decided for the sentencing to be 900. You get me, Umar?
Yeah, I get the question. I've asked him this
question. Now the Attorney General has told us that Aisha Huang was prosecuted under 995.
Under 995, yes. But
and 995 is the amendment is a self-contained legislation.
Yes. Yes. He's
self-contained in the sense that the offense and the punishment is provided therein.
Right.
Okay. Why will you canvass on the court? Or why will the court then go back to 900 to impose a sentencing regime which to all intents and purposes is non-existent, because it has been amended.
Right.
Not part of the statute books of Ghana.
Right. Well, he's sort of brought some clarity on this, but I'd allow him, since he's here, I think I would allow him to once again explain why she's charged under she's tried under a different regime, but punished under an old regime. Honorable, don't get tired of us, because it's it's a pretty, you know what I mean? It's not as straightforward for us mere mortals as you lawyers. But Honorable also wants to know from you, so please explain.
Umar, this is not an inquisition.
Right.
I believe that Mr. Deputy Attorney General is an officer of the law, and I believe that he is also very passionate.
True.
about protecting the country.
Right.
Now, we all in the studio, Ghanaians, the good people of this country, have a responsibility to ensure that we carry the people of Ghana along.
Okay.
I have said, and I still believe, that the sentencing of Aisha Huang under 900 was a slap on the wrist and would not serve to deter anybody from the mining sites.
Okay.
And so it will be interesting and very important for the Attorney General to carry all of us along and convince us that that was the best they could do in the circumstances.
No, that's very important. Honorable.
Yes. Now, we are also very passionate about this issue. Illegal mining is devastating our environment. We are all at the receiving end of the effects of illegal mining operations. Now, in terms of the sentencing, I think we all agree that we did not impose a sentence. But what the judge did was that the accused person, Aisha Huang, was convicted under the new law. But when it came to punishment, he then referred to Article 19(6) of our Constitution, which is to the effect that a person convicted cannot be punished more than the existing sentence at the time, I emphasize, at the time of the commission of that offense. And so the judge then fell back to see when was the offense, when were the offenses committed. They were committed between 2015 and 2017. And what was the highest punishment under the section that we charged here? 5 years. We would have wished, if we had our way, to have the new sentencing regime being carried through. But a constitutional provision was cited by the court to back her decision. Unless, of course, as I explained earlier, there is a higher authority like a court of appeal or a Supreme Court. Once again, looking at the provision of Article 19(6) to see whether, upon a proper interpretation, a person convicted can be sentenced. Sorry, a person convicted under a new law can be sentenced more than the sentence that existed at the time that the offense was committed. It's an interesting area, but let me indicate that the judge applied the Constitution. But as to whether that's the proper interpretation is where we are all looking at.
Okay. Oh no, I hope you're good now. You're okay.
Yeah, that is the interpretation. That's the official interpretation, and I'm happy to say that I support the Attorney General's decision to go to court to test the propriety of the decision, the ruling of the court. But my last point, and that is my opinion. I will say that because what we are discussing is the law. I mean, the jurisprudence, the science of the law, how the law should operate to bring order in society. But now, my opinion, the Deputy Attorney General, Aisha Huang, when we deported her in 2007, returned to Ghana. There is evidence out there that Aisha Huang, when she returned, she was engaged in the activities for which she was deported. And the Small Scale Miners Association has spoken out vociferously on the activities of Aisha Huang since she illegally re-entered the country in 2009 or thereabouts. Now, in fact, there is evidence that it is not our security services who found out Aisha Huang. It is because of her activities and the competition she was generating in the small-scale mining sector that led to some of her competitors giving out the information that this one was back in town. Attorney General or Deputy Attorney General, is it the case that when Aisha Huang came back to Ghana and was engaged in the activities for which she was deported, the investigative authorities could not assemble enough evidence for you to prosecute Aisha Huang on Act 995 and provide evidence. I know time doesn't run against the Commission of Foreign Affairs. So you are right when prosecuting Aisha Huang under the 2015 Acts and for the 2015 Acts and 2017 Acts, because time doesn't run against the Commission of a Crime. But were you hard put into getting evidence to establish the fact that since her illegal re-entry into the country, Aisha Huang was continuing with the activities for which she was deported and then canvassed forcefully for a sentencing regime that was not only harsh but deterrent? So it is a case that the investigative authorities just filled the Attorney General's office.
Okay. Honorable.
Mm-hmm.
Yes. In fact, when we were drafting the charge sheet, we were looking at the possibility of getting evidence to also charge her for offense that she committed upon getting back to Ghana. But unfortunately, the investigations that were done by our investigators, the police service, we couldn't find a scintilla of evidence to the effect that upon her return, she was engaged in illegal mining operations. If we had it, I can assure my learned senior that we didn't have to close it because we knew that the 2015-2017 was quite just a punishment. It was not all that straightforward. But if we had gotten evidence that she did something upon her return in 2022, we'll have prosecuted her, and then we'll have maybe not been here today talking about 5 years, but talking about at least 20 years imprisonment. So it's about evidence. We didn't have it, and we had to do what we had to make sure that we got this kind of conviction.
Okay. No, you want to
answer. Concluding remarks, and then I'll leave you because I'm far away. I know people are sitting in the studio.
I get that.
So I'll just conclude.
Okay, quickly.
Illegal small-scale mining is dangerous. Illegal mining itself is dangerous. It's a threat to our very existence. I think you would have known that our water bodies, or most of our water bodies, around areas where mining takes place are dead. They can't support any life. There is so much hard chemicals in the water bodies that fishes cannot survive. Tomorrow, if you and I and all the small-scale miners and illegal small-scale miners and all miners, or if the country passes a law, it takes a policy of non-mining, for Ghana to come back into the East-Eastern state, it was before the devastation, it will take more than 100 years. It means that all of us living on Earth today, only a few were privileged to see Ghana return without mining. So what we are being confronted with is an existential threat to our own survival.
Right.
And so because of that, we should not put short-term profits by greedy and inconsiderate persons above our lives. Because I say that good people, and Shakespeare said it in Macbeth, good people are always more than bad people. But it is when the good people refuse to act that the bad people take over. How do we explain that in 2017 and 2018, when there was a total ban, and I think that's what Nana Gentua is referring to, when there was a total ban on small-scale mining, Ghana exported huge quantities of gold from the small-scale mining sector. Little wonder that Frimpong Boateng revealed in his report that there were activities of the security services that were detrimental to the fight against illegal small-scale mining, or small-scale mining actually, because at that time, there was a total ban. Now, apart from the devastation to our environment and the threat to the economic base, and you would have recalled that the European Union issued a warning Ghana, because of the presence of sanitary or our failure to meet sanitary and phytosanitary conditions in the exportation of our cocoa. It means when we exported our cocoa to the European Union, they found traces of substances that were undesirable.
Yeah.
And so they issued a warning. Now, if those traces, and we're still using them, if those traces, unless we use what we call phytoremedial methods or oxidation and remove these hard substances from the soil, they will seep into our cocoa. They will seep into our banana. They will seep into our orange. Even if we don't export these edibles, these fruits to outside the country, we ourselves will consume them, and we might be consuming hard substances that are above the normal, and so being a threat to us.
Okay.
You see, and so I have said that it appears the government has failed. And we should go what most other countries have done.
Okay.
Communities should take the fight and make it their own. No chief can preside over a people if the people don't want you to preside over them.
Okay.
History of chieftaincy was simply that the people elected that these people appear to have leadership qualities, so we want them to lead us.
Okay.
And as time went on, it consolidated and it became a chieftaincy institution or a chieftaincy, a family that produces chiefs.
Okay.
So if the people decide that, no, our chief cannot lead us, we take the defense of our communities into our own hands. And it is not new. The Waka, the Wasa communities against mining, they stood up against the devastating effect of large-scale mining in the Wasa communities. And they fought to ensure that their environment is not degraded. In Fuji, far away Fuji, the Maoris have opposed a government policy to give concessions to miners to mine. They just believe that they want their simple life and to enjoy the benefits of life.
Yeah, I wish we had more time. I know the passion with which you attach to this topic. We'll see whether next week and next week Saturday we can do a part 2 of this. But I'm so grateful that you made time to join us.
Thank you. Thank you so very much.
Thank you so very much. The Honorable Yunus Hussein is former member of Parliament for the Tamale Central Constituency. We're just going to take a 30-second break. When we come back, Nanea Janto has a question for the Deputy Attorney General, and then Lawyer Dankwa would also give us his take, and then Nanea would wrap it all up for us, and then we can leave. And I'll tell you what, buying the land is very important. It's one of the best investments that you can make in Ghana today. And I'm talking about buying a genuine land, and Estates Masters is the company I want to introduce to you. They have the Dwellis Court, which is located within the Ningo Pram district. It's 15 minutes away from the Central University, and the next cottage is at Chopoli, close to the newly proposed airport, and 15 minutes drive from the Segelemi government affordable housing project. So it's only 22,500. It's only 22,500. Even if you can't afford it, you can look for Nanaya to try and help you raise some funds for it. She knows a number of friends who can help you raise 22,500. So you can also become a landowner. Call 0500304447, 0500304447, or 0249 363776, 0241 363776. Please, I beg you. The Naya matter that I said, I was just I was joking. I'm sorry. We'll take a short break. We'll be right back. All right, welcome back. This is Inside Pages on Metro Television. We have just about 8 minutes. So let me just say that the Deputy Attorney General has gracefully been with us since the start of the program. We're so grateful that he's still with us. Nanea Jantwa is the former General Secretary of the CPP, and also Lawyer Pia Dankwa is a member of the Movement for Change. Let me also say a big thanks to Honorable Yunus Hussein, former Member of Parliament for the Tamale Central, and also former Lands and Natural Resources Minister. We have just 8 minutes. So Nanea Jantwa needs to seek some clarity from the Deputy Attorney General on the Aisha Huang case and some comments that he's made, after which Lawyer Pia Dankwa would also give us his concluding remarks. So Nanea, you want to ask the Deputy General?
Yes.
Yes. Attorney General requesting.
Yeah, good morning, Honorable. I just want to find out, you said that the law cannot be applied if it is retrospective.
Right.
Like the crime was committed before and the law has been repealed. The explanation you gave didn't come out well. That is why Moro kept asking and asking. Because my simple mind, I'm not a lawyer. The crime is an old crime. It was committed at a time that a certain law existed.
Right.
And when the crime was committed, the law was there. And if it has been repealed, it's not sitting well. I'm not a lawyer. And secondly, I just want to find out which of the two laws are punitive. Is it the old one or the new one? Don't teach us as you are teaching a law class, because we don't have that capacity. I know you are a lecturer or once a lecturer. So
Right.
don't teach us. So teach us like you are teaching dummies for law, so that we understand it. Thank you.
Nana, you have the capacity, but still, you have the capacity more than any other. But I'll take my time.
Okay.
Yes, the first question, that you have an old law and someone has committed an offense under the old law, and subsequently this law has been repealed, can that person still be punished under, or can he be prosecuted under the old law? The answer is yes.
Okay.
If there is a new law that has made a provision to the effect that such a conduct is still punishable. So let me explain again. So under the old law, engaging in illegal mining operations was illegal and punishable. Under the new law, it's also punishable. So the new law has rather substituted the old law. So you cannot argue that because that law has been repealed, you cannot be tried for the offenses that you committed under that old law. No, the law is that the existing law will be used to prosecute you. But when it comes to punishment, that is where the difference comes.
When it comes to punishment, when it comes to the sentence,
the sentence. When it comes to sentence, if the old law prescribed a sentence, you cannot punish the person beyond the maximum sentence under the old law.
Okay.
However, if the new law has prescribed a reduced sentence, the law says that you must punish that person under the new law.
Okay. That's question
So it's for
number
the
one
benefit of the accused person that if the old law is there, don't punish the person beyond the maximum sentence. Use it. But if the new law has reduced the old law, then use the new law to the benefit of the accused person.
Okay now.
Yes, I'm fine.
And the second question about the punishment, about the sentences.
So which one is more
this is what we have. The new law prescribes a higher punishment.
Okay.
Under the new law, the minimum sentence for a Ghanaian is 15 years. And the maximum punishment, 25 years.
Right. Okay.
Under the new law, the minimum punishment for a foreigner is 20 years. And the punishment for it, and the maximum 25.
Okay.
But under the old law, the minimum, there's no minimum. You can be punished up to 5 years.
Okay.
Whether a Ghanaian or a foreigner. Or you can be fined up to 3,000 penalty units, whether a Ghanaian or a foreigner. I hope I'll be able to explain myself well.
We're fine. Yeah. But just if you can do this in just 30 seconds, if it's possible. The likes of lawyer Martin Kwebu and Kenashigbe are complaining that, of course, Kwame Asedu and co, who have taken this matter to the Criminal Investigations Department. I'm talking about the Akonta mining matter. They're saying that in almost a year, the CID says they never are going to complete investigations into the activities of Akonta mining. When in the opinion of the 4 persons who have taken the matter to the police, there's more than enough evidence to prosecute Akonta mining. What's happening?
Yes, this issue came up within the week. So we contacted the police CID, and we were told that they are still investigating. They are not done the investigations.
Yeah.
So we on them when they finished the document before they to us for us to review. So that was on Thursday, we made a contact and they said they had not finished as at Thursday. So it's still something that the police are working on. Okay. You see, in our country, we do not investigate the Attorney General. That's the problem. We fall on other agencies. In the US, they have their own investigators, so they can then manage and know how fast they can go. Okay. So that's the news for you, my brother.
All right. Thank you so very much, Honorable. We have just 2 minutes. I don't know how we're going to do this, but Honorable, let me bring it. You haven't spoken.
Oh, yeah, let the butterfly speak.
In conclusion, what are you saying? I mean, after all the things.
No, so essentially, as I want to commend my senior here as for a good job done. Right. But then, most important to add that this issue of Galamsey is a national issue. Right. I think it's the manner in which we handle it is symptomatic of how we handle all issues. See, the reason why we do politics, whether partisan, the only reason why we do politics is to bring about development in of our country. Right. And in that regard, for me, we should always seek to put the interest of the nation ahead of our individual parties and even personal interest. The reason why we are unable to fight the Galamsey issue is because it's essentially a political issue. As in, we play a manner of partisan politics with it, right from President Kufuor's time. When President Kufuor through Operation Flash Out attempted to fight Galamsey, the NDC fought against him, saying that when they come, they will help the Galamsey people. In 2016, the MPP also capitalized on Galamsey, the NDC's fight against Galamsey. I think it is necessary that we understand that this is a matter of national interest, right. And that's where the movement for change comes in. Now we are proposing to create a government of national interest, where we intend to place the interest of the nation first. Okay. And that attitude, that principle will guide how the movement of change handles all issues. Right. Because unless we realize and we tackle this issue as a national issue, unless we are committed in enforcing the law, irrespective of your political standing, irrespective of your political color, then tomorrow, this battle will be a lost one.
All right. 1 minute.
Yeah, I think that we should approach Galamsey like we all approach COVID. Right. I mean, it wasn't partisan, it wasn't political, because the pictures we are seeing are not pleasant. Imagine these pictures are on CNN. Yeah. What kind of image is it going to create?
It's an indictment on us.
Yes, it's an indictment, because now CNN is even running something about a slave project where Ghanaian children are on the Volta Lake fishing. And that doesn't look pleasant. Yeah. And to imagine that what we are seeing, even we seeing this, is unpalatable. Yeah. But I'm urging the police to profile this man and look for him. Right. Because he's supervising over an illegality.
I agree with you.
Yes.
Thank you so very much, Nanaya Jantwa, the former General Secretary of the CPP, and also Laya Apia Dankwa is a member of the Movement for Change. Mr. Alfred Tiayabua is the Deputy Attorney General. My name is Aldo Moro, and big thanks to the Honorable Eunice Afusedi for also joining us. Have a wonderful weekend. Thank you. Bye-bye.